Licensing agreements form the backbone of intellectual property transactions across the global business landscape. These critical legal documents allow one party to grant another the right to use their intellectual property under specific conditions. A licensing agreement is a contract between the owner of a patent, brand, or trademark and someone who wants to use these protected assets. The license grants permission to the licensee while establishing clear guidelines that must be followed. Most agreements include financial arrangements where the licensee pays for the privilege of using the intellectual property. These agreements provide essential legal protection for both parties involved. They define rights and obligations, ensure compliance with intellectual property laws, and help businesses expand their market reach while generating passive revenue through royalties. Standard licensing agreements contain several key elements. Contract length establishes the duration of the agreement, with specific start and end dates. Payment terms outline the amount, schedule, and calculation methods for licensing fees or royalties. Exclusivity clauses determine whether the licensee has sole rights to the intellectual property or if the licensor can grant licenses to others. Quality control provisions protect the licensor's brand by ensuring the licensee maintains certain standards. Dispute resolution clauses specify how disagreements will be handled, often through arbitration rather than costly court proceedings. Territorial agreements define the geographic regions where the license applies, which is particularly important for international business. Other important elements include inventory requirements, minimum sales thresholds, oversight provisions, and renewal rules. Many agreements also address patent applications, returns and allowances, and sub-licensing rights. Additional clauses that strengthen licensing agreements include indemnification provisions that specify responsibility for legal costs if third parties sue over the licensed property. Governing law clauses establish which jurisdictions' laws apply to the agreement. Force majeure provisions protect both parties from liability due to unforeseen circumstances like natural disasters or government actions. Confidentiality and non-disclosure sections ensure proprietary information remains private, while audit rights allow the licensor to verify financial records and royalty payments. These elements work together to create a comprehensive legal framework for intellectual property use. Licensing agreements come in three main types. Exclusive licenses grant the licensee the sole right to use the intellectual property, with even the licensor giving up usage rights during the agreement period. These command the highest fees due to their exclusivity. Non-exclusive licenses allow multiple licensees to use the same intellectual property simultaneously, with the licensor retaining the right to grant additional licenses. These are the most common type of licensing agreement. Sole licenses fall between these two options, giving the licensee the sole right to use the property while the licensor retains usage rights as well. These typically cost more than non-exclusive licenses, but less than exclusive ones. Different industries utilize specialized licensing agreements. Software companies use end-user license agreements to define how customers can use their programs. Technology firms license patented innovations to other businesses for product development. Trademark licensing allows companies to use established brands on their products in exchange for royalties. Franchise agreements grant the right to operate a business under an established brand name, complete with operational guidelines. The entertainment industry relies heavily on licensing for music, film, and television content. Despite their benefits, licensing agreements present several common challenges. Royalty disputes frequently arise over revenue calculations and payment schedules. Quality control enforcement requires vigilant monitoring to maintain brand reputation. Determining whether to grant exclusive or non-exclusive rights involves complex business consideration. Termination conditions must clearly outline circumstances for ending agreements prematurely. International licensing adds complexity due to varying intellectual property laws across countries. Enforcing licensing agreements requires proactive measures. Regular audits verify accurate royalty payments. Quality control inspections ensure compliance with standards. Legal remedies like cease and desist letters, arbitration, or litigation address contract breaches. Clear termination clauses define when agreements can be canceled for non-compliance. The consequences of operating without proper licensing agreements can be severe. Businesses risk intellectual property infringement, revenue loss, and costly legal disputes. Without clear terms, both licensors and licensees face uncertainty about their rights and obligations. From a business perspective, licensors typically hold more power in negotiations since they own the valuable intellectual property others want to use. Key negotiation points include pricing, exclusivity, and usage rights. Royalties typically range from 6 to 10%, though this varies based on the intellectual property's quality and the licensee's needs. Creating an effective licensing agreement requires careful consideration of all these elements. While templates exist, complex intellectual property matters often benefit from professional legal assistance to ensure all parties' interests are protected. Licensing agreements represent a powerful tool for businesses to monetize their intellectual property while expanding their market reach. When properly structured, these agreements create mutually beneficial relationships that drive innovation and growth across the global economy.